All right, I'm going to do a little bit different process than everyone has been accustomed to, and I'm going to use this MacGyver setup here to go through this video. And what I'm going to play is through the Richard Vobes show, or the Vobes show, and it's a conversation between Richard and Mark, peacekeepers, trying to give some depth to our relationship with the monarchy and the government. And I think they do a great job. I mean, I wish I could articulate as well as these two guys do. They're definitely pros, or have dealt with different, within their own life, have dealt with this topic many a times. And I'm not here to, find fault. I'm not here to say, hey, look at these guys, what some people do. I'm here to help us get a better handle of what law is and to explain what law is, so that when we discuss things like this, which is very valuable, this podcast here is extremely valuable, that we can then go to each thing that's said and discuss it to what measuring of how they are saying it. Now, this is what I'm going to come out right off the start. Do any of these gentlemen know what law is? And the answer is no, they don't. And that is across the board with majority. I have only come to learn what law is within the last 4 or 5 years, I guess it's been. So it is not something that is, well, I guess it's an epidemic, in as much as that we've never been taught the law, so we're trying to ascertain what our rights are within a system that we have not any comprehension of what that system is. And that's what the English Law Series is about. So what I'm going to do is I'm going to do a completely different approach here. I'm just going to I'm going to stop the video, going to comment on it and stuff like that. And sometimes I'm going to even stop this video so that I can write some notes or something, and then get to then regain my focus and speak to that certain topic. So instead of going through just letting the video play and then stop and then start, and it might take a lot longer by doing that process. So this way I will just see where it's going to work beneficial to me to start it and stop it, and then begin anew and see if I can create a video but through this process. I haven't done this before, so we'll find out. All right, so Mark of Peacekeepers is generally just having a discussion whereby Richard is asking him to better explain to them what is going on, essentially based on what agreements we have with Parliament and why are they running so readily roughshod over our rights. And it seems that we don't have a voice. Well, we don't have a voice because our voice is constrained to the level of awareness we have based on the agreements that we are inadvertently making. That's essentially it. We are making agreements every moment of the day, and those agreements are then reflected in how the court and the system sees us. They can only deal with how we present ourselves. That is the only way in which they can respond. Now, Mark lays the groundwork effectively of what Parliament is and how it relates to us and so forth. And I'm going to just give you a little bit more depth into what he's explaining, so we have a deeper explanatory means in which to then arrive at where we are maybe going wrong in our comprehension of what Parliament actually is and what the monarchy actually is. Okay? Now, Mark goes into the two houses. He says there's one house being the spiritual and temporal lords, and then we have the lords in commons. Okay, so let's just look at that. And it's better to say that when you're listening to anything that I'm talking about, what maybe a way of explaining it is what Richard and Mark are doing. It's explaining, guys, here's the elephant in the room. This is the problem. We have to dissect this elephant piecemeal and to get the full picture of what the elephant is. Is even have an idea of the image of the elephant itself. We are going to the elephant, we're dissecting each piece, we're going to, like a puzzle, we're going to create it until we arrive at the elephant. I, on the other hand, am discussing the room the elephant is in. That is never discussed. So we deal with the house of spiritual, the house of Parliament, and we're dealing with the Lord spiritual, the one house of spiritual in Commons. Well, we know spiritual through looking back at Edward I, law of mortmain, and I think it was around 1290. And whether speaking to the corporation, being the Roman Catholic Church, who have no rights to the common law. Common laws are personal agreements between the individual and the monarchy of the time. Okay, there's not a group dynamic, in as much as there's the laws that form the confinements for each individual, but each individual is making a personal agreement. The three interests. Maybe I'll just finish with spiritual. So spiritual have no rights in common law. They have rights to an estate within a common law interest that they can regulate over, that they can administrate over. That's not subject to common law rules because they can't be seen in common law anyway because they're a perpetuity instrument. As we discussed, we're dealing with the common law. If we're dealing with common law, we're dealing with individual rights and agreements in honor, and where the church is a collective agreement, so a legal personage, a fiction, that's dealing with a right to the use of land subject to, not immediately subject to, but its own set of rules to that use of land that's not seen in the common law. But they do intermingle because of the fact they know what each other interest is. Okay? The Lord's temporal would be those estates that have created through the personal interest, that we can even go before William the Conqueror of AD 1066, and we had those elite, those men of wisdom, if you say, our wisdom that discuss their issues and their land interests with the king as one sort of consortium, okay, with a final say-so being the king, but heavily influenced by those lords of the time, because they were the ones, the keeper of the law and the wisdom. And then we move into AD 1066, and then we had William the Conqueror. Now he's got this vast of land, and he's got a lot of dissension because he's got those who held manors prior to William coming on board. And then we have agreements and promises made to the knights who helped William conquer that land. And then we have those large tracts of land that serve as an agricultural aggregate for everyone. And then we have, even the church dealing with certain issues that they have. So we have a lot of different issues with establishing the common law. So essentially, Lords Temporal were those who, through their personal agreements, handed estates originally through what we learned with liberation, so it had to be a physical effort of holding some substance and passing it on to another, which was by and seen within witnesses. Thereby everybody knew that land that lord held was completely transferred to the new recipient. Okay, so the grantor to the grantee. So they held that. Now the grantee becomes the grantor. There is no agreement with the previous lord. It is cut and dry right there. The entire estate is moved over, and all of those obligations associated with holding that land now transferred to that new person. That was the liberation. That is the only way those interests were managed and transferred, was through a life. All right. So they then, those who didn't transfer the land, or let's say the grantee now becomes the grantor, he can now move his interest, not generally by controlling it, and that's how we moved into equity and wills and stuff like that, is he had to move customary to the laws that were already set in motion, that were annexed to the land in that manner through a fee. So at the death of the lord, he could only then transfer it through bloodlines. okay, through primogeniture. Generally, that's how it was held, and it was always the first male for the first stint, but we're not going to get into that point. But generally, he could only pass those strict laws of inheritance, that common law interest, to which that new heir could only be realized at the death of his father. And at that point, he had to take care of all other encumbrances and debts and incidents which were owed to the king, and warships and marriages and so forth. He had to make that agreement and settle before he then held that interest from that term on. But those would be the Lord's temporal. And even with, with the surgeonry, those manors which were those who agreed with William the Conqueror, that were prior to William the Conqueror and held large manors, and said, yeah, we'll go with the military style means in which how you want to run the feudal land tenure system. And they kept their large tract of lands, and those that abandoned the large tracts because they didn't want to be coming under William Conqueror, or they got killed in the battle, those were promised through William Conqueror to their knights, and that's what the knights held. And for that knight service, from there on, they held that land through the service and allegiance to the king to provide knight service. Okay, I'm not going to get into the Franklin one, and I'm not going to get into the agricultural, the stockage end of things. We'll just leave that out of here. But Lord's temporal would be the ones of wisdom, if you will, the ones that hold still those large settlements. Commons are those who can never hold a large settlement because, again, they're just gone through the laws of inheritance. They'll never be able to hold a piece of land in that under the common law, so they come in under equity, and that, like the system of the Roman Church, who only has the rights of the equitable interest to land, then those people come under that, okay, under equity, and they could then control interest in equity, which are equitable titles, that then become legal when then they create titles under them, like leaseholds and other things for people to use under them. So it's just a pyramid structure, but it's directly, House of Commons is the equitable use to land, the second level use to land, first level is that which is held in the monarchy, but controlled by those lords temporal. Okay? All right. I hope that's a good introduction. That gives you a better, more substance to what we're discussing when we get into this topic here of what Mark wants to bring to our attention.
So the first thing is, it's a contractual relationship. Therefore, without consent, nothing can be done, and that is expressed and admitted by the mere fact of the Bill of Rights. So everything must be by consent. And again, the relationship is expressed in there, that nothing can be done to the prejudice of the people.
Yeah, let's just stop it right here. It is a contractual agreement, but it's not a contractual agreement between the people. As we have learned, the only agreement that the people are involved in, and that's through an operational law right from birth, okay, is between the individual and the monarchy, just the same as the lords are between the lords as an individual against the monarchy, which then solidifies the common law agreement. Okay, people do not have any. I'm going to bring this up again because he's going to bring this up later on about putting a pool of money together to dangle the carrot for somebody to come up front and be presenting an obligation that the people have signed that allow Parliament to now effect their rights to control the people. Well, again, there is no contract of trust with Parliament. You have none. You have none with the House of Commons. There is none. And you don't have any directly with the House of Lord Spiritual or Temporal. You have one only through the monarchy, who is your liaison between yourself and the government, to which then the Bill of Rights 1688 is an agreement between Parliament and the monarchy, not the Parliament and the people. So what they're saying essentially is that you have to adhere to those rules of the the people when the people exercise that right. But guess what? There are no technical people when they're all coming in under the agreement of citizenry, which is essentially I'm an employee of a corporation. I'm not saying that Parliament's a corporation, so it is a perpetuity instrument. Okay, they're under rules of patent, but that the citizenry through their own actions are creating that agreement, therefore overreaching their rights with the operational law and the agreement with monarchy. So their Parliament, that agreement, is just saying, hey, when the people show up and they want to, you can't interfere, just like House of Commons can interfere with those Lords Temporal and Spiritual, because they're dealing with a different subject matter. But the Lords Spiritual and Temporal will create the foundations how they want their proprietorships held, and then the Commons then agree, well, what we can do, with our workforce in order to, affect, to not totally, destroy the land that we're using, okay? Because essentially, a House of Commons and is setting through a trust the rights of immunity from the scrutiny of the Lords looking over your shoulder every day, every tree you cut down, and so forth. That you now have full reign, full immunity through the trust, as long as you control the accounting and make sure we're paid for it on our end. So that's all that's really happening. So there is no contract with the people and Parliament ever. You're never going to get that. Never see it. Okay? I don't care how much money you put into that pot. It doesn't exist. So, at that point, let's move on.
When the Mary accepted the crown and the royal prerogative, they accepted on the condition that everything expressed in there is for the people. It starts off with the claim that the members of Parliament are the representatives of the estates of the people. However, the acceptance of the contract changed that offer to be of the people. And like I say, then in 1700, because the monarch still didn't understand that they can't.
That point I don't really understand, and don't believe me, you may not want to have said it that way. I'm not sure. I make mistakes when I look at the videos later on too. So it's only through the repetition of going through the videos and getting over some of my, my mumbling or misuse of words that you'll start to get the tract. Oh, he made a mistake as well when he said it. So I don't get to the point where it says exclusively in that Bill of Rights, in the preamble, and who it's addressing, that it says, the Lord Spiritual Temple and of Commons agreed to uphold the estates of the people. Okay, that's not verbatim. That's just paraphrasing. Okay, so don't come back to me. That's not what it says. I'm just giving you some sort of context to what's saying here. Where did the estates get eliminated? Because as we're learning, English law only deals with land. And this is really important because people are saying, well, how am I enforced to do something I don't want to do, right? When it's also in the mind that slavery's been abolished. In fact, slavery is abhorrent to English law, common law, okay? And involuntary servitude likewise. So how is it that I'm getting forced into something? Well, there's a really good point here, and this is the room that the elephant is in, is Parliament can only deal with the estates, those estate interests that are held in common law and equity, to which then create a obligation through the individual and how they want to address, purchase of property, or if they're a baron or lord and stuff like that, how they want to be, subject to the agreements directly with the monarchy in common law. So estates are essentially another word for status. So it can only deal with those estates based on the level of subject matter that each interest and part of house is working towards. So Lord Spiritual have a different estate interest on behalf of the people. Temporal have a different estate interest on behalf of the people, and commons have a different estate interest on behalf of the people. It's not of the people first, so I don't know where that came in. You're not dealing with people. You never, Parliament can't, so it's a fiction of law, it's a perpetuity instrument. It can't deal with people, okay? So I just want to clarify that. All right, let's move on here.
Can't do what they want anymore. That Parliament itself expressly defined the law as the birthright of the people, and those governing must uphold our birthright. So this is the...
Right, Act of Settlement, 1700. No one's arguing that it's not the birthright of the people. It's stated right there. But the birthright of the people is the law, and that means they have free will to use any part of that law they want to. So if they want to come in under government, they can. If they want to be an agent of government, they can. If they want to be a minister, then they have. A minister can't hold free and common stockage interest as a citizen can. If a minister does, then they can't be a minister because it's directly subject to an agreement with the monarchy. So, the initial point being that the Act of Settlements clearly state 1700 it's the birthright of the people. So it still is. No one is in disagreement with that. The only issue is what agreements are you making so that the law can then react and create a determination based on what interest you're holding, what estate are you holding, which essentially again would be synonymous with the idea of status against that subject matter. What are you holding in order to affect a certain interest? Because that's going to create a certain level of agreements subject to it's going to create a set of laws that are now going to administrate over that agreement. All right?
Written constitution. That there is expressed as fact.
Right.
Sorry?
Well, I wanted to ask you some questions about all of that. On the one hand, so I've got three little questions that were occurring to me as you were talking there. First, if the people are the ones that have effectively got together and organised the fact that there is the Parliament and the royal prerogative, what's to stop the people deciding, do you know what, we're not happy with that anymore, we're going to start something completely different, whether it be a gaggle of elders or a witan or a different type of organisation to administer?
The Bill of Rights actually is the legal precedent which allows you to do that.
Right. So
the Bill of Rights is saying, it says in there,
right,
it's our ancient right and liberty to do that.
Mm-hmm.
And basically, what have they done in substance? They've removed the existing king who is tyrannical and replaced it with another one. Therefore, exactly like you say, you simply need the Bill of Rights, because that bears the precedent which says if those governing are no longer fit for purpose, just replace them.
Right.
Okay. And I stopped there. I mean, that was great knowledge and great discussion about the if we're ever, if Parliament is ever coming and imposing its will upon us, we can then now stop Parliament from acting, or just replace Parliament and replace whoever is the party that is being the troublemaker, if you will, or whoever's posting their will. But remember, we're not dealing with Parliament directly. So can the people then go and start distorting the foundations of the Bill of Rights, which then did create parliamentary privilege? Can we go in there and start disrupting all of their rules and regulations? No, we can't. We're not interested in that, in as much as those are holding certain interest for our benefit, which our benefit will only be realized when we fully come into comprehension of what law is, so that we can vest our legal estate that was created at birth until that estate no longer is held in trust. Thereby we need no trustees or no agreements with monarchy, who, and this is important, it's monarchy that we address that then will then come in and saying, hey, what do you guys think you're doing? You can't impose your will on to Dave here. He has vested his interest. He's got his legal estate, and so you have no rights to even just talk to him. Okay, and if you're enforcing your will, now you're going to come to me because I hold the common law, to which then I gave you through the possession and evolution of law. I gave you the right to even address those matters that you hold and those parliamentary privileges that you hold. I gave those to you. To now, a new title was created through William and Mary in Orange, whereby they are the constitutional monarchy, meaning they are of the same nature, and the rights to those interests which are derived in are created within equity and through trust. So a constitutional monarchy can only speak. So when Queen Elizabeth is wearing that crown, if you will, she's speaking to Parliament through a constitutional monarchy and discussing those equitable interests that the government is allowed to use through grant. Okay, and then addressing the worker bees, if you will, like a union. Okay, and saying, okay, now you can do this and do that, based on what I have to hold, which the monarchy holds, that common law against the common law interest. So you can go ahead. So more or less, the monarchy is saying, you go ahead and I'm going to grant you a right to come as proprietorship, as government, and use that land, use that territory. That's what it is. It's a territorial jurisdiction, and that agreement has to be solidified through the Bill of Rights and every other document that they do between each other after the instillment of the constitutional monarchy. But there's the other private crown that you also hear. You don't hear the coronation oath or whatever oath that they want to call it. I'm not sure. But that is to hold the common law interests that are established within the people, to which then the land in 1688 moved out from the monarchy, who was despotic monarchy, all land went into the monarchy as holder, as absolute owner, to then be transferred because James II abdicated the throne, and that throne, even though it's abdicated, still sets the foundational principles as the vehicle for the common law. Okay, it holds those legal interests. Those are still there. They're destroyed. Are there still lords? Well, yeah, Lord's Temple. It proves right there. There's still barons. Yeah, so there's still agreements. Those agreements are still held. But are you privy to those agreements? No. You are coming in under governments to which then the monarchy has a contract with, to which then the government then sees you no different within itself as being one collective cohesive unit of a legal personality subject to that agreement that they hold between the monarchy and themselves. But the people have a different one because the land interest now removed from the despotic monarchy as being the tyranny or being, that's the evolution of the law where less and less rights were given to the monarchy, but the common law had to be settled, and that's what it is. It's settled, but now the land is moved into the people. It had to be in order for things to be lawful, because as we know, you have full dominion rights. They did made mention to it, I think in chapter Genesis 126 and 128 or something like that, where he's saying that we have full dominion over the land. Yeah, that is a absolute right, but that's a recognition of natural law. It's not a recognition of the common law. It's a recognition of natural law that's obviously inheritable to each individual that's born of nature, because everything's gifted. And here's another thing. Government can't patent nature. It doesn't. The monarchy doesn't patent nature. It patents the right to the use of land when man himself or the people have sort of abdicated in themselves by not controlling that interest, removing it outside from English law. So the monarchy comes in, holds that interest. Now it's available for use, so production can be had, and that use then is an equitable use, to which then creates a legal right that gives on to granted to the government through patents to hold that territorial right for the second level use to land in equity. All right. I don't know if I need to continue on with where he's going on this. Let's see.
Right. So I'm thinking in a huger way of, rather than just voting in another party, etc. The whole damn lot is a shambles, and you'd find a whole different way of organising us that would work for us. So my second question.
Basically, okay, we need to understand it's always a problem about enforcement.
All right. You know what? I'm just going to jump ahead to. We've got a good foundation. That's what I wanted to get to. What I'm going to do is going to pause this video, and then I'm going to come back in where I want to speak to another matter. All right, keyed up another spot here. Let's just go on.
So that is the fictions there. But fictions, humanity wouldn't be able to interact without the fictions of law.
True.
I.e., how does somebody, my word is my bond, but if we record that in writing, we need to associate with that. And so there's a massive debate about words. So the word person is where many people spend a lot of energy trying to argue, I'm not a person, I'm a living man, I'm a living woman. Okay? So with this living man or living woman, if you look at the Interpretations Act, so again, a legal definition, a legislative...
Sorry if you wanted to listen to that a little longer, but I want to make a point. I agree. How can we live without fictions? You can't. In fact, English law has to create the legal fiction because you have to create a status. And the reason why you create a status, so you create a set of duties and powers, prohibitions and limitations to that status so it can't go beyond that. Okay? So, for instance, if I am fully vested in my legal estate in the common law and my right to that interest, now I have 9/10 possession. 9/10 of possession is the law. Now, I want to go and I want to tract the land. Well, I don't want to deal with English law again, okay? Because English law is a hierarchical system of land holding. That's all it is. So how would I do that? Well, I would have to go and claim land because I'm not purchasing. I'm not within the jewelry banking system. I'm in my own absolute right at that time through dominion to now go to the land as it is freely given through nature. Okay, so I would have to go say, well, here's my tract of land, and then make claim to it, and then that's pretty much what I should get into that point. But the proponent or the necessity of legal fiction is to create a rule that can continue on ad infinitum for as long as that purpose is in effect. So I made some reference. You just imagine if you wanted to create a university and each time the dean died you have to start from square one. Well, the reason what you do then is create the powers and duties for that dean so that anyone that takes that position now is given an oath to come in under the duties and powers of that position and only that position, and therefore is confinement. That's what every time you give an oath, and I'm sure it's in the Bible, don't give an oath, it just means confinement. You're confining yourself to strict rules and regulations. And that regulation is only established by having a perpetuity instrument such as a legal fiction. Now the next point he makes is, now he goes into the Interpretation Act of persons. Okay, he's right to say, we don't need to get caught up in the idea of persons. Okay, persons, it's all you can deal with in English law because they're subject to a legal personage and a legal status. It's the only way that you can deal with English law. Okay, so don't get caught up in the idea of persons. You need to get your comprehension is, what is the subject matter? Subject matter and your status create jurisdiction that you can be heard in for proper determination to effect a remedy. So you have to know what those are. And if you're dealing with a common law legal interest, your status is completely different than that would be obviously if you were, let's say, a settler of a trust under government, because that's a completely different subject matter, just like House of Temporals have a different subject matter they're controlling than those of House of Commons. Okay, subject matter is important. So let's not get caught up in persons. But he brought in the Interpretation Act. Now, I believe it's 44H here, the Canada Interpretation Act. You guys in Britain, or sorry, UK, or wherever you are, New Zealand, Australia, even in US. Because the US guys, hey, let's get over this point right away here, nip this in the butt. You are still subject indirectly to the monarchy, but the monarchy in common law, not the one in equity and not the constitutional monarchy. That's what you won the battle of. Your republic is an equitable use to land because only government and a group can ever own an equitable use because they are a perpetuity instrument, not a life. So you get that. Okay, so U.S. as agreement is subject to the rule of law of English law. You guys are using English law, all right? The Interpretation Act, 44H I think it is, it says that essentially no law can be repealed unless it is of the same subject matter. There's some great words to anchor. If you go into, and you'll find out that a law has been repealed if it is of the same subject matter. Of course, the government can repeal as much laws as it wants to within its ability under its grant that it's been given. It's like a union. The union can only fight with the dynamic of that union, okay, and what it's been granted. You cannot now go into in the auspices of, well, I don't want to use that word. Can't go into the relative nature of what gives legislation its power to then look over those agreements with the union, because the union has to be a unit with its confinement that can only address Parliament and legislation in that manner. Okay, so if government is dealing with union, it's going to then legislate certain rules and rights or rules of law determinable to or against that union. And then that, if anything gets repealed, it's going to be of that same subject matter. Okay? But then if we go into the higher echelon of things, that subject matter that Parliament has a right to, and the House of Commons, okay, and let's say the House of Parliament here in Canada or one in Australia, it can only deal with that subject matter and repeal that. But it could never repeal anything in the common law. It has no interest in common law. It has no interest with the people. And it has no direct interest with the monarchy that's holding that crown and the private rights in the common law. It only has those agreements that it can deal with effectively with the constitutional monarchy that was instilled in 1688. Okay, so I wanted to bring the Interpretation Act. I don't think I need to speak to the idea of persons anymore. It's pretty self-evident now. So the reason why I brought this in is because if you want to go to the Interpretation Act, it will completely and succinctly say it only will repeal laws that are of the same subject matter. That's important. All right, I'm going to pause this video and see where else I can get to. Okay, and roll.
So if I'm the occupier of a house,
yes,
I'm the substance, the form is just the occupier, but equity prevails over the form. So I don't waste my time sitting and arguing, oh, my name should be big letters or small letters. Why? Equity stands above the common law.
All right, there it is. The common misnomer, the common mistake, the mistake that I made for so long when I was comprehending equity. And people are just all, enamored and rolling in the idea of the spirit of the law. That's the law I want to use. Well, as we've already ascertained, equity is a different subject matter altogether, okay? And you're only going to get those same right interest as what is available in equity under a trust. That means if there's a trust, then the legal estate in the common law has to be held in there, to which you will never, ever, ever have rights as long as you are serving an equitable interest, to which Parliament deals with. Okay? So this idea, using, okay, the maximum law within equity, that, or even if you look into your customary laws within each territory of your state or province or wherever you're at, is it will say where there's a conflict between common law and equity, equity should prevail. Let's break that down for a minute. So we're going to eliminate this common issue. First of all, what common law are you speaking about? There's a common law, customary laws that are dealt with in each territory or each province or each state. Then there's one at the federal, okay? Then there's the English common law, and that's the one that we're only ever interested in, is the English common law. We have no interest in those matters of common law of territorial jurisdictions. It's the same idea. This is copy-pasted from the feudal land tenure system, where a knight held that manor or that land tenure, to which then he only spoke to the monarchy, mano a mano. Okay, he went to the king's court, and that's where they heard. And then they had the curia regis, and they had the Star Chamber, and all those kind of things. Okay, that was their courts. But those who worked, those who held copyholds, villains, those of serfs and peasants and so forth, the laborers, they had no right to the common law because they could never hold a legal interest in common law. Okay? They were not granted one. So how do you then deal with those people? Well, you create courts within each manor, to which then the baron and the lords that are under the baron would administrate over for common grievances between that manor. Well, it's the same thing with the territory, the proprietorships of Canada, US, or anything else. That's another manor. That's another proprietorship. And those courts then deal effectively with those interests that are common within that territory. But they're all under English law, as we've already discussed. So equity prevails in equity. Why? It has to. Why can you create injunctions against common law? Why could you even create injunctions back in the time of the English common law? Well, because in the interest of keeping the peace, they had lords, or the chancellor, who was the right ear or the right hand, if you will, of the king, in order to maintain the peace, would have to go into disturbances and listen to those disturbances that were created with those people having equitable use to land. All right? And if it was an agreement of an equitable use and there was no common law interest, of course, then it would totally deal with that manner. That is how common law and equity is separate. It has to be different subject matters, completely different subject matters. One held in trust, one not in a trust. Okay? So equity prevails in as much as that the court, as a court of chancery, is independent, who then rules, I guess, albeit under legislative authority, but he interprets the law, and he has the right to enforce the law through his own determinations. He doesn't need the interpretation of the boards and everything else. He can make one independently, and that's what the courts did as they moved through manor to manor, okay, as the chancellor did in order to maintain the peace. So equity prevails because never is a common law, the English common law, ever even seen, but it's also, we're dealing with a common law, which is within the territorial right, to which then equity is the superior law, because there's equity that they're dealing with an equitable interest to land. So it will always supersede the common law when there's a conflict. So that's what we needed to get down to, because that is so, I've heard that debate for so long, and it's got to be nipped in the bud that it is the worst misnomer, and how we automatically circumvent our true power by using that and by using equity. Our legal interest, is already determined, is in the common law, and our agreement is through operation law with the monarchy only. There is no agreement with Parliament. Okay, so there, I'm glad that that was brought up, and I'll pause this video and see what else we got here. And roll them.
So I don't waste my time sitting and arguing, oh, my name should be big letters or small letters. Why? Equity stands above the common law. It's a high...
So let me just ask you this then to try and clarify that in my mind, because there's so much of this that can be muddling, and as you say, you know, people get very het up on certain things, and so I just want to try and clear myself. When a policeman says to you about a situation and then asks you if you understand, I've heard that actually means that do you stand under my authority?
No. Again, utter nonsense. Okay? Now, the substance is, we speak a common language called English. And it's the reason, in a court, it would be down to a reasonable person's understanding.
Okay. Yeah, the first point he made, we've already discussed already, and the word of understand. And I agree, there is, you know, we are trying to not affect a contract with a compulsory agent or anyone else in government that we don't want to deal effectively with. So when we say understand, what does that really mean? Well, I use this as people come to, you know, have either read some of my posts or even some of my comments, and I use it on occasion through my videos. I use the word understand, and I'm going to tell you why. If right now I was listening to these guys, as we're doing right now, and I said, yeah, I understand everything he says. Okay. I understand what he's talking about. Well, I do. But I only understand through my own understanding. So when I talk, or when I'm listening to these guys will not have the same ability to discern what it is that, what level I am understanding. So let's say that two people are speeding and a cop pulls them over. Now, when he's asking to the participant with a driver license, or not even a driver license, still doesn't understand what law is, he's going to ask, do you understand? Well, yes, you understand to your level of awareness of that incident. Now, let's say let's put myself in the driver's seat. When the cop comes to me, I understand what he says, but I understand it on a whole different level of what he's talking about and what he's dealing with. So that's why I like to use the word understand, because you are the law. And that's another thing too, I can quickly jump into. You bring the law into the courtroom. You bring the law wherever you go. You are the law. You represent the law. No one is pushing any of their wills against any of their enforcing anything or having enforcement over anything that you against your will. Okay? No one's doing that. You are understanding based on the comprehension you have at that time, exactly as we're watching this video. They're going to deal with Parliament, they're going to deal with court, and they're going to deal with compulsory agents completely different than I will. Okay? My understanding is understanding what they're doing, but they will not have yet the ability to understand what I comprehend, because they are yet to discover what law is. Okay? So I just wanted to get that little point out. Just small, but it sort of develops what we're trying to do in this whole English law series. All right, we're rolling.
So what you're saying is that some of this legalese that you hear about, when people are talking to you, the double meaning, as it were, is not as binding.
It's not binding. For anything to be binding, there must be a meeting of the minds.
Right.
If there's not a meeting of the minds, it cannot be binding.
Okay.
Or when people use words like implied consent or acquiesce or all of this, if there's not a meeting of the minds, there can be no bond.
But how do you deal with them if you've gone to court, for example, which I know you're doing this, and you're arguing against a legal system that is pretty much set up against, because they seem to be a money-making machine.
Correct.
Interest. Yeah, and there's going to be a conflict of interest, and so they're going to use all these hidden techniques, such as things like what I've heard the 12 presumptions that you are
Yeah.
supposed to, you know, that's assumed about you, and
Yeah.
then, unless you rebut them, they'll use them, like trustees, whether you're a trustee, whether you're the executor, or the beneficiary. What do you think about those?
Okay.
I think maybe I'll just stop it there. I might have just pushed it a little too long. I think there's going to be another point that I'll make after this one. But Mark has, made reference to that it has to be binding. It has to be mutual consent, and that's correct. If you are involving yourself in a contract or there's a trust agreement, okay. But again, when he's gone into the tacit and implied consent, when Mark goes into court within the same mannerism that he understands law, whether he's going to speak equity. So automatically the court's going to give him the correct the form of court in order to deal with his matter. He's never going to be able to deal with that common law interest. Now let's just say that Mark didn't want to just deal in equity. He wasn't really sure. He just said, he just went in there, but he started speaking. I'm not saying he does this. I don't think he does this. But I am, I'm man, I'm a living being. I've got these inheritable rights, and then he immediately goes into the idea of a constitutional right, and then he brings in the 1688 Bill of Rights, or he brings in the U.S. Constitution, or he brings in his right to property that he fully owns it. He paid off his mortgage and yada yada yada. Well, what is happening there? If that person has now commingled dominion, which is his absolute right, which is never to be transferred, can only be taken away if you commit a felony, you're removed of the law, or you become a monk or whatever, that kind of thing. But you have the dominion right, so he's bringing in that aspect. So under natural law, okay, then he's bringing in his rights that he thinks he has to property, which would be a common law legal interest that we've already discussed, but he's now using an equitable argument. So automatically, because equity prevails, especially under territory, the judge will revert to the less strictest of law, because that person's not able to speak the law yet. They're speaking still in ambiguity, where they're commingling a couple different interests and not understanding what it is that they're effectively are trying to say. So the implied agreement comes in, whereby because that individual, as an individual, we don't need to discuss whether the person is alive or dead. That's irrelevant, just like the idea irrelevant of a person, which Mark had brought into as well. It's irrelevant, that argument. Just by your words, you're already going to be then thrown into a constructive trust, because you're not speaking to the trust that is holding your legal interest and you're not knowing where that is, because you're not dealing with a common law. So equity is the soft approach. That's why it's the spirit of law. It allows you to make as many mistakes as you want to, and it's very forgiving. Equity is forgiving because it's going to address your own inability to speak to the law and carry the law. Well, again, you're only carrying the law in as much as you can carry it by your own knowledge. So it's going to allow you to do whatever way you want to. It's going to give you as much room as you want. I've seen videos where people shared where a person's standing up in court and they've got this list, and they're thinking, "Oh, those are all great points. Oh man, that's phenomenal. Oh, I can see how the judge is listening to this. He's slinkering down. He's caught. Deer in headlights kind of thing." No. The judge is just allowing you to prove the point that you don't know what law is, and you're going to throw yourself back in equity. And when it's all said and done, because equity, he's giving you the ability to be forgiven for your trespass, essentially, against yourself and your true interest, to allow you to be fully heard, so that when the judge makes a determination to say, let's go set this up for trial, and essentially it seems like he ignored everything you just said, but because he's saying, hey, this person had proven, here it is, recorded, everything else, that they don't know what law is, what their interest is, what the subject matter is. They don't know And because they're commingling, we have to be forgiven because the common law is very strict and it's settled. We're going to go into the arbitrary nature of equity, throw them into constructive trust, and then we're going to manage the constructive trust for them. Okay? All right. This next part, I'm going to be stopping it in each little part in succinction. So to discuss how the story gets developed and the description gets developed. And I think that this is going to now give us a better semblance of how we, from what I've already spoken to, of how it all comes together and coalesces in this last little bit where we're going to just go bang, we're going to break it, we're going to break it, we're going to break it, we're going to break the chain, and then from there we'll have a better comprehension exactly why we find ourselves within this quagmire and this mess and finding ourselves being pressured by an institution that has no power and never said it had any power in the first place, to which they only have as much power as we give them. Okay, let's roll, and like I said, I'm just going to completely start and stop it.
How do you deal with them if you've gone to court, for example, which I know you're doing this, and you're arguing against a legal system that is pretty much set up against because they seem to be a money-making machine.
Correct.
Interest. Yeah, and there's going to be a conflict of interest, and so they're going to use all these hidden techniques, such as things like what I've heard the 12 presumptions that you are supposed to, that's assumed about you, and then, unless you rebut them, they'll use them, like trustees, whether you're a trustee, whether you're the executor, or the beneficiary. What do you think about those?
Okay, so...
All right, just quickly on that point, now we're going into what generally the common agreement between all of those who are starting to see the elephant in the room and piece things together. We're looking at the tyranny that the government is exercising, and it doesn't matter how much you prove and how many times you go to court and show them where they are wrong. The court has to look to the agreement just like they did in equity. They circumvented the common law in order to look to the agreement in order to maintain the peace. So who is giving the power to these governments? The governments are only ruling, administrating over that grant they've been given, that patent that they've accepted. So they cannot go past that or explain that or interfere with your true common law rights or your rights as a live sentient being. They cannot deal with that. Okay, it's very important that we deal with this. So when we go into this idea of trustees and so forth, which we're going to jump into right away, we're going to now look at those being essentially, obviously, duties and powers. Because if you're a trustee, that means you have a certain duty and power. If you're a settler, same thing. Beneficiary, same thing. Okay, and so by going through this next little bit, and we've got the foundation that we've already established. We're not involved in any contracts of trust with Parliament or government. That there is no obligation when we are affecting our true dominion rights and those interests in common law, that legal estate. Okay, so now we've got a segue. In as much as now he's going to get into the idea of trustees and beneficiaries and see what we can do from here.
I mean, this is very common. People are under the belief that they shouldn't pay for life living, and I absolutely agree with it.
Okay, are people paying for life and living? No. We're all in agreement in this. He's not saying anything that doesn't make any sense there, because obviously we have to have dominion. But why, as we already acknowledged, why are we then feeling that we are paying for life? Obviously, we're affecting the wrong subject matter, because if we don't want to pay for that subject matter, then we stop acting as citizens, more or less as quasi-trustees, who got a third level of use to land. So are we paying for land? No, actually we're paying for our own self to, we're paying to ourselves in an account in the private for using the land as an estate, as an equitable interest under government. So all licenses, all your bylaws and ordinances and permits and all those are accounting of what's owed to you when you settle that interest in the common law, because that's how you, that's the full value vested back into you for the use of the land that government then has regulated and administrated under. So that has to be held in trust. That's in the private. That's not in the public. Okay, we're just exchanging monopoly money, promises. We don't own anything. You're an assumed owner under government. You can't be any higher value than that, because essentially you're a tenant for life under the status who's a quasi-trustee enfranchisement of the government, just like you'd be an employee of any corporation. You are subject to those rules while you agree to hold those interests and get those privileges assigned to you through your own actions to then intercourse and purchase and do all that kind of thing. All right? Okay, so let's carry on.
Okay, and the reason is, and it's expressed in Genesis 1:26 to 1:28, I think, that actually expresses the trust. The Creator created all of this and granted us life and granted us, all the people, dominion over the land and everything else. What it didn't do, okay, is say who's the trustee. So what it says is, we all are trustees of the land that we possess, and we have the beneficial right to the seasonal fruits, and we have the trustee obligation to future generations not to knowingly cause it harm. Right?
Okay, descriptive view, and this is what we're getting at. We're getting to the explanation. I would probably best put it this way. There is no trust at all between you and laws of nature. You cannot make an agreement with laws of nature. You do not ask laws of nature for your heart to beat at a certain time and stop at certain times. You cannot discuss how you digest your food. You don't ask permission of the tree before you cut it down. You don't then imbibe into the seed, this is what I want you to do, I want you to grow. Those are all non-agreements. That's creation. And we have this ability. Well, the system, as soon as you deal with a system, you're dealing with a fiction. Okay, and anything under government, regulated under government, that's churches, that's all your religions and beliefs and so forth, are subject to agreements between man and that fiction that create truth through the facts of that fiction. Okay? So, if we're speaking about creation, it has nothing to do with man, in as much when man starts making agreements. That's outside of laws of nature itself. There's laws of nature, and then there's also natural law. Natural law is those laws that man, in honor, say, you know, I'm not going to harm you, you're not going to harm me. That's essentially what it is, okay? Laws of nature is non-agreement. So if anyone says, you know, the God of the Bible is this, this, and that, he's a creator, it's the creator of those agreements. That's what we're speaking about under the Judeo God. The Jews' God is, and the chosen people, because they chose that God in order to administrate their rights over the possession of land and that interest to which they can't ever have possession of land in common law. They can only have possession of land through the process of creating debts against the use of that fruit on the land as an equitable interest. Okay, so I guess what, you know, the point that I've just got myself off track to some degree because I've sort of, you know, dug into it more, but there is no trust. You're not making a trust. If you're in nature and there's no one else around, there is no agreements. Okay, there's the laws of nature. It just exists as it is, fully and completely. Okay, so rather than anything within your agreement with, see again, it's not even an agreement with laws of nature because there is none. It's a confidence. You know, the sun will rise in the east and set in the west. You know, the way there's the ebb and flow of tides. The birds have their own laws in which to fly. Those are all non-agreements, and it's a confidence that's imposed in nature. There is no agreement. There is no trust. Okay, trust is a man concept. In fact, with you through operation of law, you have no trust with the monarchy. How could you? Do you have a trust with the monarchy? If you don't even understand what the monarchy stands for and what it holds, how could you even create a trust? We talked about that earlier. Mark did. It said you got to have a meeting of the minds. Well, there is none. So that's why it's done through an operational law. What you have is a confidence through law, to which then I will put any agreement. That's a God. There's nothing wrong with it. That's when we say we're prostrating before God and the Father and everything else. The establishment of those agreements that we want to create honor within in order to affect a cohesiveness and peacefulness within the society. That's the God. That's an agreement. Okay? So there is no trust. And we are just stewards in as much as that we are agreeing to that God of agreements between each other, because we have to make them in order to communicate if we want to build societies. We have to we have to say that the sky is blue. We have to come to that agreement. We have to say this is soil. We have to say that this is a tree. Is the tree a tree? No, it's not. Those are labels, those are words. And that's, I even think in the Bible, so, in the beginning was the Word. The Word, there it is an agreement. That shows you absolutely that you're not talking about the laws of nature. You're talking about the Word. You're saying that's a tree. Well, the tree is not the tree. It is, if you get caught up in the idea of the description of what we've labeled it, then you're going to get into the agreement, therefore circumventing the laws of nature. But that's okay. But just know you're doing it. And that's what we learn. Where do you begin and the fiction begins? Okay? If you don't know what the fiction is, you're going to commingle everything, and that's why we have issues with the free men and sovereign movement, and we have people doing protest, and we have transgender agreements. We have all these agreements going all over the place. Well, people can agree whatever they want to agree to. Okay? If you're forced into it, I'll tell you what's happening, and I was going to bring this a little bit later on, but hey, it's coming to my mind right now, is because you're agreeing to be a citizen, then overreach. That's the overreaching agreement that everyone has set up as a legal personage in society. So it's democracy. You've all agreed to. The democracy holds that value, and doesn't matter what protest you do, you're only going to have a freedom of speech and freedom of religion within that agreement. That's steadfast. But I'm here, and the monarchy's here, and the government's here, and the citizens here. Okay? So depending on where I'm at and what I'm discussing, then warrants how I'll interact with those type of ideas. I'm not subjugated to those ideas because I'm not of the world. I have no interest in the world. I know what the world is. Now you do as well. So once you know where the fiction begins and you end and vice versa, then from the principle to which government can never ever discuss, that's what we never deal, science doesn't deal with the ether, it doesn't deal with, there is no such thing as speed of light or sound, there's no such thing as an electron, there's no idea, there's no concept of true, how we receive energy, that it's opposite, because even Tesla says energy is an induction, it's not something that then is generated, then we create, it's an induction process, it comes to us, we don't go out to it. See, the system is all about sending the ripples out. I'm talking about 0 point, where you begin, okay? That's where all energy is. That totally eliminates the idea of viruses, all that crap. That's all pseudoscience, okay? And that's what we get caught up into. And I went off, but I'm just going where it's going, baby. Okay, let's carry on here.
We must apply the best available knowledge at all times so that we don't wreck the place for future generations. So that's the trust relationship. So in law, there's something called trustee du sang, which which is a very well-established common law tort. So what should happen is those governments...
Sorry, something just came to mind. He says, so we're entrusted with the land now so that we don't wreck it for future generations. Okay, are we wrecking it for future generations? Come on, look around. Look around. Are we wrecking it? Well, the reason why we're wrecking it, because the Parliament is a separation between the common law interest and the equitable interest, therefore has immunity to create waste. The more waste it creates, okay, the more power it's granted by creating legislation to manage that waste. You see what? See, the more damage we do to ourselves, the more power you give to legislation, because that's what legislation is granted with, to manage the accounting of the waste that's created while it's in use. Do you see what's happening? All they're doing is they're creating, it's a Hegelian dialectic, because that is what government works on. It doesn't work on common sense or principle, or morals or ethics. It doesn't have any rights to those, in as much as that's instilled in the people, okay, as an individual, as self-proximity. Okay, that's where your morals, your ethics, and everything else are created. If fiction cannot be held responsible for morals, it can recognize them, but to the degree of its people that it's administrating over, and those people are becoming immoral because they're playing the game to bankrupt their neighbor, destroy the environment through creating more waste that then creates more legislation and more power for government to administrate over. So we're shooting ourselves in the foot. We always have been. Okay? So I wanted to get that out too. I thought that was a great, just a little point of how if we want to be 100% responsible, means 100%. And when people blame, and listen, I get it. I'm there. I've been there ever since I went down the rabbit hole. Even before that, back in 2005, the elite are doing this, the secret societies are doing this, the system's doing that, Parliament's doing that, my neighbor's doing this to me. Immediately, when you point the finger, how many fingers are pointing back on you? And that is more true than ever I've ever uttered those words. Because if you are the one that wants to be 100% responsible, then where does your responsibility begin? Well, your responsibility begins when you're letting your intent known. And where is your full intent to be realized? Well, that's in the common law, and that's with dealing with that interest held in the monarchy. And the monarchy, as like I said, is a confidence. It's not even a trust. It's a confidence to impose that title, which is that private interest held in a different crown position than those held under a constitutional monarchy, that's going to hold the common law as God. That's law. God is law. So when you swear an allegiance to God, you're swearing allegiance to uphold the law of that common law interest for and on behalf of the people. So whenever we want to deal with that interest exclusively, then we're dealing with it. Okay?
Two jobs. One is to uphold the rule of law, and the second is to make sure everybody gets a fair share of the Creator's pie. So, in effect, what should happen when we die, we have no being. Whatever we've been entrusted with for future generations should return to society and get given to the most needy. And so that's the trust relationship. However, what's happened is, through legislation, those governing have created privileges for certain people, which again is against their own legislation. The Statute of Monopoly 1623 says any grant of a privilege is unlawful. Right. Yet they continue doing this. So,
wow, I'm going to touch on that. I'm just going to pause this for a minute because I've got to ask a question to somebody here. 1 second. Sorry, I got two mouses here, and sometimes I push the wrong button, so there's with that little, awkward pause. I'm trying to push buttons, and what I'm thinking I'm doing, I'm not doing, and I'm going to be ending well, you don't need to know that I'm going to be ending the video because I can just come back to it and continue on. But just to hit it on that point, where we're getting to is that the idea that Parliament is giving privileges to those members where they shouldn't be, based on an act of, I believe he said 1928. Did I write it down here? I think he said 1928. 16. Oh, sorry. What am I saying? Statute of Monopoly, 1623, and where privileges are unlawful. Well, you know, that's the devil's in the details. Of course, privileges are unlawful because they have nothing to do with those interests of man, which is the full right of dominion. So as soon as you accept a privilege, means that you have now come in under an agreement. If you come to an agreement, that means that overreaches your dominion right, because in order to give that agreement value, then that privilege is unlawful. Okay, we look at the bigger picture now. We gotta look at the room the elephant is in. Okay, instead of just picking piecemeal the elephant itself. So yes, privileges are. Same with oaths, and I think people bring out ideas like, in the Bible that the person is against the will of God. If God's the law, the Father law, then yes, personhood would be, because it's a privilege you're accepting to be created an equitable interest, which is the same interest that the Jews are can have rights to, and the Christians who are just the really much, it's just the servants of the Jews, because the Jews are the chosen people, because that's their God. So, so that's important, that nothing's again being broken here. No one's circumventing the law. The individual is circumventing the law by his own interest that he's continuing to hold under Parliament, which is a privilege. So you're the one who's creating the problem and going against or solidifying the statute monopoly of 1623 by your own actions. Okay, you're accepting a privilege. And government can do what it wants to with its privileges because it has parliamentary privilege. That's what it received in 1688 in the Bill of Rights. It can do what it was granted based on the agreements it gets. The more agreements it gets, and more people creating waste, the more law, as I've already mentioned, is established, and those privileges are assigned based on the oath you give to uphold those. If you're an ambassador, you have a different set of rules than a minister has, and then a minister has a set of rules than a deputy has, deputy minister, or the legal services branch. You know what? Anyone who has, I don't care if you have the highest responsibility, the bigger, the more power of your title, that's a huge burden, because you have to hold that to make sure that that's never overreached, and any other power below it, subordinate to it, doesn't get overreached. And you have to make sure those alignments are all in cohesiveness, so that it doesn't interfere with the people who are before the law, because of the mentioned before, you're not under English law. Okay? You are subject to your agreements which overreach your dominion rights. So if you want to deal with an agreement in English law, it means that you're dealing with something that can do with land and land interest, to which then creates an obligation. As soon as you hold that land, you're fulfilling, you have essentially said that I have now agreed to overreach my dominion rights to come in under English law to hold that land interest and be secured, and whatever that means. There is no security, that's another illusion within that land interest and that status that you want to be represented by. If you want to give an oath, go ahead, but that means you can never deal with the private side of that of your legal estate interest, because you have by oath absolved that to come in under that position. So it's backwards. Anyone that has a title within English law, that means you've disagreed to a confinement under that system, and never could go into the full power of each individual that each individual has, if they're standing in the dominion rights and have vested that legal interest. Okay, Mark just okay, just the previous feed, we're just at the fact that he was making that the privileges based on the statute monopoly of 1623 is unlawful. Okay, so continue with that. Now, I think after this point, because I've got to go and do something, I'm going to pause it. Now, if I come back and also somehow my video gets stops and I'm able to continue on, then I'm happy with the video so far and going through this great podcast. That I think that I think we better have a better handle of what law is and where what agreements that we're making, and essentially, if we want to be 100% responsible, it is up to us, and it's not up to Parliament to babysit us, and it's not up to someone to nurture us and feed us and wean us off the system. It is up to us to come to know what that law is. Everything's held in trust since infancy, because as an infant, you can't control your life interest. You can't make any allegiances to the monarchy. You can't create contract for lack of mutuality. You can't do anything. You don't even understand law. So that legal interest has to be put into trust and managed by trustees so that it's separated, so that anyone that's using the land from there on doesn't impede or doesn't dilute your inheritance when you are of age to vest that inheritance. Okay, so there is nothing wrong with the system. The system's not broken. Everything's perfected. If in order for everything to roll and unimpeded and waiting for you, let's say an infant to reach age 21, a majority to understand what law is, we can't just keep on stalling. I mean, land's got to be able to be used for those people that want to use it. So it's just put into trust, and then the government then regulates the rights to use that land under a second level, to which then the citizen uses the third level and make purchases as assumed owner of that property. But essentially it's a quasi-trustee, and that's why the system goes against you, because you have an obligation as a quasi-trustee, because you're saying a citizen and you're coming in under those, you're waving your hand about constitutions, you're holding your pitchfork, defending that property right, and you're doing all these things under Parliament, which then just tells Parliament and tells the court system that you are still not ready to make your intent known and deal effectively with that legal estate that's held in common law. Okay, so I'm just going to play a little bit of this, and I think I've got to get going, but let's just see where we go from here.
So what they've done is, through legislation and the common law over time, the government, or the true intent of the trustee, has failed. They should ensure everybody has a fair share of the pie, and what's happened is, through privileges which even legislatively is unlawful, they've granted certain privileges to certain people to benefit, i.e. self-interest. All right.
So I think I'm going to end it there. I don't think we need to go any further than this. We see where the misnomer is, the mistake is, and it's always going to be the same thing. What is law? Do you understand what law is? You need to answer that question. You need to look in the mirror and realize when you're just following like all the, people say, when they started adorning face diapers and roll up their sleeves, when there's no such thing as the idea that they presented in the public, which is just another fictional concept in order, and I'm going to get to the ending here, in order to move the people into a fourth level of trust, unbeknownst to them, because they don't understand what law is and what their agreements are in the first place, then have to create ideas and concepts and operations like CIA. They're creating an operation in order to move and take away the property rights of the people who are only holding that property right under the agreement of government, who holds a 99-year lease, and that lease is coming to an end, so it's moving all those interests that it held into the full rights to administrate under trustees who will now command all property rights, and that's why they're creating new titles called 50-minute cities, like they created a new title with the constitutional monarchy, as they created new titles in equity. We just create new titles, new systems, 1925. They created the new titles for under a trust for sale scheme. 99 years later, they're moving into new titles, 50-minute cities. Now that 50-minute cities, the same comparable as we just experienced through since 1925, the last 97 years, we just experienced purchasing titles under that construct, and then taking the property titles that were before 1925, putting them into mortgages and creating a new title, to which then we sold and traded among each other. Now they're creating ending this 99-year lease under a trust for sale, selling that, the accounting, moving to a fourth level of a trust whereby no more citizen rights, no more quasi-trustees. It's all going to be put back in the hands of the trustees. And thereby, the new titles they're going to create is the 50-minute cities. Those 50-minute cities will now be regulated with new rules and new legislation subject to that. So we just keep on getting narrower and narrower and constructing it smaller and smaller. But in the interest of the people who are on the other side, well, now it's going to give the land a rest, and all the waste that the citizens have created. I was a citizen, no longer one, of course, but I created all the waste. I bankrupt my neighbor. I created disease. I created cancer. I donated to continue this movement so that my pension can grow, and we've done it, okay? And we did it with borrowed money, monopoly money, because that's all it is. And we've done that. So now this whole movement into 50-minute cities is the benefit for Earth, so that the inheritance of those people that are on the other side, to which you can get to, now can receive the rewards and allow the Earth to reclaim itself and get back to some semblance of equilibrium and homeostasis, okay? So there it is. I think we got it. Well, that's the longest video I've done, but wow, I think we did do well to uncover a lot. I hope you enjoyed this. Please like, share, subscribe. Let as many people as you know to start entertaining, looking into law instead of being controlled by our own inability and our own ignorance to know what we're agreeing to. And by all means, if you feel compelled or have the ability, any donation is greatly appreciated. It doesn't matter how much. And thank you for everyone that's donated this far. Love it. It goes right back into the research and help creating content, and helps me as well as taking care of some of my own bills while I'm researching topics and researching the law for everyone's benefit. And with that, thank you for listening. Oh, wrong mouse again. God bless.